Online and copyright, and this brings me to Pinterest, Tumblr, Facebook, all of those sorts of things. Contrary to some popular belief, the laws of copyright don't suddenly disappear or change when we talk about online. Practice might, technology might enable a whole lot of things, but the laws, those basic principles that I've outlined, are exactly the same. People have rights, they should be protected, there are exceptions to the rules. All that stuff that I said translates into the digital world. Pinterest, and I had a look at their copyright notice, just about every website now has a copyright policy on their website. I was reading Tumblr's. I'd be a little bit concerned about that if I were an artist and I had works about printing them. I was just looking at them as our artist was talking about Tumblr. And some other sites, Facebook has recently changed its things, but you need to look at the terms that any website has on its as its copyright policy. Some of them will say that they take a licence to use your work in whatever way they like, and that other users of the website can do what they will with your works. If you're happy for that, and some people absolutely are, then that's fine. If you're a professional artist and you say, I don't know that I want people making derivative works without talking to me about it, or I don't want them commercialising them in another way, then read those terms carefully before you use them, and you might want to direct traffic using a teaser sort of mechanism through to a website that you publish yourself where you have your own copyright terms and policies. Pinterest has applied the US law. It simply restated the US law and says if anybody posts infringing material on Pinterest, we will apply the notice and takedown provisions of the Digital Millennium Copyright Act. And that means if you're a copyright owner and you say, oh, someone's posted my photo up on Pinterest, they haven't asked me, that you can contact Pinterest and say, please take that down, it's my work, it's an infringing copy. Also under that law is the right of the party who has been accused of infringement to say, actually, no, that's my copyright work, and you go through this thing. Repeat offenders will have their accounts terminated according to Pinterest. But when you're using any online website, you need to look at terms and conditions and think about what the implications are for your artworks. There's some sample notices. We don't need to go over them. They go through from a very simple copyright notice that would retain all rights through to one that is saying you can do whatever you like with my thing and far less proprietorial. It's up to, of course, the owner of copyright to decide under what terms they will offer their works. Very important for artists, of course, are contracts. And I said, you know, the copyright law says these are the default positions where we don't have an agreement or a contract, but that otherwise you might want to negotiate a different position, and usually you do that under a contract. For a contract, you need an offer, and you need the other party to accept that offer. So if it's a publishing offer, you know, here's my manuscript, and a publisher might say, I will publish that and pay you an advance of a certain amount, so that's your consideration, is for some sort of valuable money to exchange hands, or an item of value to exchange hands. You need to have an intention to be legally bound. So if I'm drunk at the pub on a Friday night babbling on about my great manuscript to a publisher friend, and they say, oh, yes, we'll publish that and we'll pay you a $10,000 advance, blah, 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 and I turn up on Monday morning sobered up and I slam my manuscript down and say, where's my advance? The publisher can very well say, that was a social setting, we were both drunk, I had absolutely no intention to be legally bound, and they'd probably have a very good case. In a contract over copyright works, you need certainty over the parties who are in the contract, the works that will be covered, the rights, so is it reproduction, is it the communication right, is it the adaptation right, the time that that contract will last for, what will bring about termination of that contract, and the territories it applies to. Increasingly, people are taking world rights because that's how the web works. It doesn't usually work in territorial zones. But these are all things to think about in a contract. Some of you might wonder, well, assignment or licence. So in copyright, you can assign copyright interests. And that will mean that you are transferring all of your rights to another party. And it means that you don't have copyrights in it when you have assigned the copyright to somebody else. Under other bits of law or other things that we might think about, if you own a house and you sell it, it's a bit like an assignment because you are giving up all your interest in that property to the party that you sell it to, and an assignment is very like that. A licence, which is far more standard, is a bit more like a rental agreement where you have a lease. The copyright owner retains rights, but they license out particular rights to parties to do certain things, usually for a limited time. And it will be for specific rights, and it could be exclusive or non-exclusive. So an exclusive licence, if you're publishing a work, you probably want to take an exclusive licence from the author. You won't want to have a non-exclusive licence because you won't want other people competing with you in the marketplace for selling that work. Other rights, so say copyright agency, we take a non-exclusive copyright interest in our members' works because we want them to be able to use them in all sorts of other ways as they can. And for many uses, that will be okay because you just want it for a particular thing, and the rights owner, the copyright owner, will then be able to use it in other ways with other parties. Very briefly about us, and I won't cover this for too long because it's not really the topic for today. Copyright agency, we're a copyright management company. We're not for profit. We were formed by Australia's artists, authors and publishers back in 1974 in response to photocopying technology. We now actually have over 20,000 members, including many visual artists. We administer statutory licences for copying by educational institutions and government. The photocopying ones came about when education said we must be able to use this photocopying technology. We can copy all sorts of wonderful works for our classes. And our members, artists, authors and publishers said, but you've stopped buying our textbooks, our whole business model's just fallen apart. Very long court cases, lobbying of government followed, where we had a case that we won in the High Court that established that artists, authors and publishers did have rights in their works, and that schools and universities couldn't just make multiple copies for classrooms without permission and payment because it was undermining a legitimate economic interest. Then the lobbying of government occurred where both sides had fairly entrenched views saying must be able to use photocopying from the schools sector, and creators saying you can't, that's our right, it's our copyright. And our government actually came up with a compromise and said each side here has a very valid point, and we are not going to stop technology being used in classrooms because it is obviously public interest for students to be exposed to all sorts of works, and teachers couldn't possibly buy all books and students couldn't buy every single textbook for their personal use. So we will create a statutory licence. You can do that, there's limits, 10%, otherwise you buy the book, but you must pay equitable remuneration through a copyright agency back to artists, authors and publishers. So a beautiful compromise was reached. It's been operating for over 2 decades. We started out collecting and distributing about $1.1 million in 1989. We now collect and distribute over $130 million a year. And that's a fairly significant thing in the publishing and visual arts industries in Australia. For us to help you, you need to be a member. You need to ensure that your copyright statement reflects how you want people licensed, spelled with a C, that's very bad there, it should be an S, your works. And we will lobby on your behalf. Part of my job and other lawyers is to go down to Canberra and argue for things we think will benefit artists, authors and publishers. For instance, we have lobbied long and hard for the resale royalty, which came into action on June 9, 2010. That followed many years of lobbying by us, by NAVA and by many others, and we participate in other things. And of course the cultural fund that I manage, which is $2 million a year, and it's part of licensing revenue, and it's other artists, authors and publishers giving back to their industries for all sorts of things, including things that NAVA does, individuals to go and develop their professional skills, etc. Lots on our website about that. Very quickly I'm going to skirt through moral rights because they sit alongside copyright, and if you're doing anything with people's artistic works you should be aware of them, and also as artists you should know about these rights that you have. They developed in Europe, continental Europe, first France, then Germany. They're seen as a personal right, and rather than the economic right that is copyright. In that sense, they can't be traded. I can't assign my moral rights to anybody else. They are the artists, and they are based on the notion that anybody who creates a work has an enduring relationship with that work. All their works will form their reputation. So the only way anybody other than the artist can own moral rights is if the artist has died, because they subsist for the same duration as copyright, 70 years after the death of the artist. So the artist's heirs and estate can own moral rights and exercise them after they die. So you can see the third point there is very true. The copyright owner and the moral rights owner in a work can be different. So if you're doing something with a work, you may have to deal with two different parties. There are three main rights in moral rights. For a long time we've had the right of attribution, and that's the right to be identified as a creator of a work. So to have your name, if there's an exhibition, a name on those plates by artworks to say that you are the artist of them. If you write a book, to have your name on the cover of the book. So that's existed for a long time. Two newer rights that came into the Act in 2000, and these are all in the Copyright Act, are the right not to be falsely attributed. So somebody else can't put their name on your work, and your name can't be attached to somebody else's artwork. The important example here, these laws, and the right of integrity, which is the right not to have your artwork subjected to derogatory treatment, prejudicial to the artist's reputation. Those two later rights are new, 2000. They haven't been challenged a lot under our law. The attribution, false attribution right was challenged in a case with an artist called Meskinas, who was a portrait painter, probably still is, and he painted a portrait of Victor Chang, and who's our Tasmanian princess? Mary was photographed in front of that portrait. Women's Day, I think, was New Idea was the magazine that published that portrait and put a different artist's name under the work or attributed it to a different artist. Meskinas contacted, and then his son contacted New Idea many times to try to get the attribution corrected. They said they'd do something, they said they'd do something, they didn't do anything, they didn't do anything. They had meetings, phone calls, emails. The artist, by the time it actually wound up in court, there had been 90 different sorts of communication, nothing had happened, and the artist was 90 years old. And there might have been best intentions, but nothing happened. And of course for the artist it's important that they be attributed, because that's part of their reputation, and might lead to further commissions and all that sort of thing. The court held, of course, that his moral rights had been infringed. I think the damages that had to be paid were $10,000. So they're important rights. In other ways, they've been challenged under other jurisdictions that would probably be an example for us. A number of them come from Dutch law, so they must have a litigious lot there and a very great awareness of their moral rights. One of them was an artist whose works were displayed so high up on the walls of a gallery that they couldn't be seen. And he said, you're just trashing my works. People can't come and see them. You're treating them badly, and it's bad for my reputation. The court held that that was true and asked for damages to be paid and for the works to be shown at an appropriate height. Another one was another Dutch case. An artist had been commissioned to create sculptures that were on display outside a museum or a gallery. And they were of ducks. Christmas time came round and the staff of the cultural institution said, that'd be really neat to put some bows around that for Christmas. And the artist said, you're trivialising my work. It's a serious work and you're just trivialising it. Went to court again, they were successful. But there are some examples, practical examples from foreign jurisdictions. I think we've talked about that, and the right not to be falsely attributed. Derogatory treatment, as I said, hasn't been tried under our law, but it would be material distortion. If you did something terrible with an image and it just didn't look like the original, if you destroyed or mutilated the original, in a way that was prejudicial to the author's or the artist's reputation, or any other act. I think we've said that. Defences are if you get consent from the artist or the author. So if you say, I'm going to use your work in this way, are you okay with it? Then the artist can consent to waive their moral rights. The reasonableness of whatever it is you've done. So if you didn't attribute the artist because there just wasn't space, you had 30 different artists being shown, you made a very brief flyer, nobody was attributed, then that could be a thing where a court would say, well, it wasn't really reasonable to. So in these circumstances, what you did or didn't do was reasonable. With movable artworks, you have to give the artist a chance to record the work and also to remove it, if that's possible, before you destroy a building. I can't remember what we call that. Take it down.